to sponsor our Play the Video cruise to educate cruise, but also put them on our YouTube later so that all drivers can have access to them anytime on demand. So they're all there on our YouTube. We've used social media quite a bit to get our voice out. The picture of this lady right there, this is senior from the EEOC, was one of our first speakers on our first cruise to come and tell us about our rights. And that's something that's really lacking, is that a lot of drivers do not know their rights. They don't know what their rights are with sexual harassment, how to report it the right way, or even find a lawyer. So very quickly, you'll find this on our annual report. And I wanted to make sure that I drew your attention to this, because now with us just throwing in a little bit of this and a little bit of that, now our annual budget is a little bit over $26,000 a year, which is nothing compared to what we've had a voice around the world. We've been quoted in the Wall Street Journal, the New York Times, Cosmopolitan, Bloomberg, NPR. We are drivers, and we did this while we're driving full time. So our main topics or initiatives that we've done. We did get involved in the Truck Parking Coalition. If any of you are familiar with the Truck Parking Coalition, that was started because of Jason Rivenberg's murder. It started Jason's law by his wife, his widow, that gave birth to his twins right after he was murdered. My social media activity and exposure to the public made me be somebody that a lot of people ask questions to, including Alan and Donna. Stayed with the Truck Parking Coalition. I continue to go to meetings. There's going to be one here Saturday morning. If you're a driver, get involved in that. I did a webinar for the Women's Bureau 2014 to talk about trucking. In 2015, also, I was asked to make a sexual harassment. It had never been asked before. The company that asked me to do it makes safety videos for the big trucking carriers in our industry. They make the CSA videos and the 3 points of contact videos and all these things that all the motor carriers have to train their drivers. They came to me and said, would you make this webinar for sexual harassment? Nobody's teaching the drivers. We want to have it in our library. I worked really super hard on it. And as soon as they started advertising it, somebody called and canceled it. Somebody in this industry called and canceled it. They don't want us to have this education. You need to have this education to protect yourself from sexual harassment and sex assaults. So the time is over for that. We're not going to accept that anymore, that you're going to cancel a presentation to teach people how to protect themselves. This year, we were represented by Public Justice. And I've been if anybody's followed me on social media, I've talked a lot about the sexual harassment. Public Justice represented us to unseal court documents in the CRST sex harassment case. A lot of the documents have been sealed and nobody's ever read about it, so it's become sort of an urban myth among drivers that it's fake, that it's not really happening. So Public Justice entered a motion for us, Real Women in Trucking, to intervene in the CRST sex harassment case, to unseal those documents, and we won. And we just started getting the first documents last week. And some of the stuff that I've read in just the first few pages, not even related to sex harassment, related to the number of people in their training program, should raise alarm bells to everyone in this industry. It is just outrageous. And some of the things that have happened to these women, it is directly related to safety. Nobody should have to go into a training program and be petrified of the person they're in the truck with. In addition to representing us in our motion to intervene, Public Justice is representing Dominic over here. Dominic is the lead in the case that the Supreme Court will hear about arbitration in the new crime thing. And I'm not saying it right. Let's go to the next slide, and I'm going to let one of you guys explain new crime versus Oliveira very quickly, if you have it. Yeah, okay. Craig actually wrote we contributed to the amicus brief in the Supreme Court case, and Craig wrote part of it. So I'm going to let him summarize what it means.
Thank you so much, Desiree, and also Alan and Donna Smith. And I want to recognize Rosie, the CEO of my firm, and all the other great lawyers. And of course, my mom's here in the audience, even though I'm 46, super embarrassing. Great to be here at the Great American Truck Show, especially with Desiree and the Real Women in Trucking. And this is a complicated, kind of boring issue, so I'm going to try to distill it in a nutshell. But a couple of years ago, they said companies are allowed to have arbitration agreements where they basically tell you can't go to court, no jury trial, any dispute has to go to arbitration. That's true for credit card companies. The original case was with AT&T, it was called Concepcion, and they further held that in that same agreement they could say no class actions are allowed, only individual case, so you can't band together. That continued on in another case called Stolt-Nielsen, where they said if the arbitration agreement is silent, that means you can only go to an individual arbitration as well, you can't band together. Now, the Federal Arbitration Act, which is the law that allows arbitration agreements to be enforceable, has an exception for transportation workers. So anybody who is a transportation worker automatically would be excluded from this rule. That means truckers, in theory, should be able to go to court, okay? Thing is, what happens if you're not a company driver, but you're an owner-operator? Okay, in all these owner-operator and all the lease agreements, they always have the arbitration clauses in there with the class action waivers. So now before the court is the interesting issue, is that considered under the Section 1 exemption, the transportation worker exemption? If independent owner-operators or independent contractors who sign these lease agreements are exempt, then those arbitration agreements are not enforceable. That issue is a lot of important stuff, particularly on the topic of misclassification, which we're going to address later, because if someone's misclassified, maybe they shouldn't have had to pay for fuel. Maybe they should have gotten paid for a lot of time that they weren't compensated for. So that's the issue in front of the Supreme Court, and we did file an amicus brief on behalf of the truck drivers in that case.
Thank you. Next slide. So we're going to talk about sexual harassment. Josh Friedman is going to talk about that. It gets very complicated, especially in these team drivers. It's not all, the solution is not that we need more female trainers. Frankly, some of the female trainers are worse than the men. Okay, what it has to do with is if you are a good trainer, and you should be training. It doesn't matter what gender that you are. So the other thing I want to point out too is a lot of times when the police get involved, they assume it's domestic violence rather than workplace violence, because it's extremely difficult to explain to law enforcement why on earth would you be on a truck with a man you don't know. And trying to explain that to an officer that your company put you in that situation and you're trying to start a new job, it's almost impossible. So we really want to clarify a lot of that. Next slide. So I'm asking you guys to listen to Josh as he talks about his cases. I'm going to move to the back of the room. He's going to tell you a little bit about himself, and I'm asking you to help us change this industry. Next slide. Okay, we already introduced our panel, so we'll just go on from.
Hi, folks. I'm Josh Friedman of Friedman and Holding. Our firm exclusively represents victims of sexual and racial harassment in class actions and multi-plaintiff cases. And, this is all we've done since 2003. First of all, I'd like to thank Desiree and Real Women in Trucking. I encourage everybody to join and support the organization. Desiree asked me to speak about about a case that our firm brought in 2015 called Sellers versus CRST. And just to, I think, give you a feel for what this case is about, I'll tell you how it all got started. I was sitting in my office, minding my own business. The phone rang, and a woman told me a horrible story. She worked for CRST Expedited, which is one of the team driving companies, the largest one, I believe. She had been sexually assaulted by 3 separate trainers or co-drivers. She had had weapons pulled on her, and it was a horror story. And then, coincidentally, I assumed, we got another call from another woman who had also been sexually assaulted by 3 separate trainers or drivers, also while working at CRST. So I thought, perhaps we can help. They expressed an interest in the possibility of settling their claims. I made an inquiry, and CRST said, yeah, great, yeah, let's settle. In the meanwhile, I just did a little background check, and to my surprise, I found that in 2007, the EEOC had brought a case on behalf of 270 women who had been raped, sexually assaulted, or sexually harassed while working at CRST. And based on the documents that were available in the court archives, it was clear that this problem had existed since the early 2000s, that at least one driver had been convicted of rape. What happened in that case was it was dismissed, and all 270 of those women were left without the opportunity for justice. Why it was dismissed isn't really important. The bottom line was, I thought, well, let me ask these women whether they experienced any of the same types of events that were described in the EEOC case. And sure enough, they did. They told me that when male drivers sexually harassed women, the only thing that happened to them is they were assigned the status of, quote, no women. That was it. And the drivers who had sexually assaulted them, or the trainers, were still going around and doing whatever they were doing without any consequence. So it became apparent that there had been essentially an epidemic of sexual assault at CRST that had started a decade ago. And even though it's extremely difficult to get a court to accept a class action where the events in question occur all over the United States, as is the case when you're talking about a trucking company, my partner and I decided we had a moral obligation to ask the 2 women we were talking to, let's not settle this, let's do something about this. Let's ask the court to certify a class action. Let's get an injunction to put an end to this. And let's actually get compensation for all of the women who are a member of our class for the sexual assaults that they've suffered. And she said, yeah, we should do it. And ultimately 3 women agreed to act as lead plaintiffs. Now, it is very difficult to get a class action certified. You have to show that there are common policies that led to the sexual harassment. Well, let me mention one name. That's Karen Carlson. And you'll notice that there's a slide up right now. And the lead attorney at our firm, Giselle Schutz, took Karen Carlson's deposition. Karen is the head of employee relations. And she testified that CRST, that it didn't deem any claim of sexual harassment unless there was either a witness or a confession. Now, virtually all of these sexual assault, sexual harassment occurred in a truck cab built for two, so there are not going to be any witnesses. And confessions, well, the only time you had confessions was just the result of the poor training that CRST did. A lot of the men that were engaging in sexual harassment didn't know it was illegal. So they said, yeah, I did that. But essentially, an attitude was apologizing women. The other piece of incredible testimony that we got is Ms. Carlson told us that each time a driver was accused of harassment, it basically presented an entirely new scenario. And even if he had been the subject of prior uncorroborated complaints, that they were not considered at all. So if you put all that together, you've got a policy of never corroborating complaints, and then you've got a policy of not considering prior uncorroborated complaints, which really boils down to never disciplining anybody for engaging in sexual assault or sexual harassment. Because of this testimony, the court in Iowa, where we brought this case, decided to certify a class of 270 women who had either been raped, sexually assaulted, or sexually harassed. That case is pending right now. And he held that CRST policies could, if the jury concluded that they were in fact those policies, actually explain why all this horrible, horrible violence against women was happening. And as Desiree mentioned, the files in this case have now been unsealed, and there's some very, very startling stuff that you can see. The types of sexual harassment that are typical are, well, it stems from the model that a lot of these trainer or joint team driving companies have. They'll pay for your training in school, for your CDL, and then they're going to put you out on the road for 28 days with your trainer. You're going to be alone in a cab with somebody you've never met before, who will, in all likelihood, be a man, because the vast majority of trainers are men. That person will have the sole discretion whether or not you pass. That means whether or not you get to go on and make money. And you already owe your company about $3,000 for that training, which requires you to work for them for 8 months under contract, and it prevents you from working for any other trucking company during those 8 months. So as you can imagine, these trainers have an enormous amount of power over the women whom they're training. What was very, very typical was for a trainer to demand sexual favors in return for passing. Sometimes they didn't even bother to demand, they just took what they wanted. Extremely vulgar, to the point of threatening. Verbal sexual harassment is common.